Welcome, everyone, to our conversation today on moving towards justice, where we're going to focus on common and strategic pretrial litigation in cases of intimate partner violence. This is part of our 10-part series on intimate partner violence. And today I'm excited to be with my colleague, Patti Powers.
Hello, Jane.
Patti and I are both attorney advisors with Equitas, a nonprofit organization that is funded to provide you with innovative, informed, and practical strategies, really geared towards helping those professionals that are working day in and day out to improve our response to domestic violence, intimate partner violence, stalking, sexual assault, and human trafficking, along with other violent crimes. We do that in a number of ways, including online resources that are available on our website, including this series, other webinars, long-form webinars, articles, research, case law compilations. So I invite you to check out our website, which is at www.equitasresource.org. We also engage in sort of like invited training events. So we'll often go to a certain location or provide online training to an office, a task force, a state, coalition maybe, but we're also involved in many national events and international training as well. We're proud to be partners and involved with several initiatives on a nationwide program or programs really. And those are sort of longer term programs that are dedicated to providing support and building coordinated responses. Some examples of those partnerships and initiatives are our Sexual Assault Kit Initiative, the Innovative Prosecution Solutions Grant, and the Enhanced Collaborative Model Human Trafficking Task Forces. One of our favorite things to do is to provide one-on-one consultations with professionals like you who may need somebody to sort of bounce off ideas, discuss strategies, or conduct some case-specific research. And we're available 24/7 for those types of consultations. You can follow us at any of these social media platforms. We usually are pushing out, some training opportunities or some new research or related articles. Today's work is supported, and we're so grateful for the Office on Violence Against Women, part of the U.S. Department of Justice. While everything Patti and I say may not be necessarily reflecting their views, their support is we couldn't do this without their support. Under the Fair Use Doctrine, we often will share innovative and new responses from others, always with acknowledgement and letting you guys know the citations for where we're finding that work. So today, Patti and I are going to be looking at intimate partner violence cases through the lens of how can we figure out what types of issues are going to be suitable for pretrial practice, and how can that enhance our success down the road? And often that will be because we want to be briefing our judges on novel legal or factual issues that they may not have seen before, and we want them to have plenty of time to reflect upon and make the appropriate determinations before the trial begins. A lot of our pretrial motions are going to involve the litigation of discovery or evidentiary issues. And we want to be doing that thinking about, are we doing everything we can ethically to protect our victims' privacy and keep them safe? So Patti, I know you practiced for 27 years. A lot of your practice was dedicated to serving victims that had experienced intimate partner violence or sexual violence. So with that lens, why is motion practice so important in these cases in particular?
Well, Jane, as a prosecutor, I spent most of my time in the courtroom. I supervised our unit but I think I was in trial most of the time as well. And I really did learn firsthand how important motion practice is to trial preparation. And we're going to talk about some of the reasons why, but there are two general areas that I think we really need to focus on. And that is, as you mentioned earlier, the need to protect the victim and to enhance our efforts to maintain their privacy to the extent that we can under the law. The other related aspect is to ensure offender accountability through the admission of appropriate evidence. And doing this pretrial is so important. The last situation that we want to be in is where very important matters are being litigated at the last moment with the need to excuse the jury from the room, which jurors do not enjoy, and sometimes even for a prolonged period of time. So this is important work that we need to do well before trial.
Mm-hmm. I always thought it was nice. You also got to sort of give the judge a glimpse of the evidence in advance, right? This idea of previewing the case for the judge. Sometimes that could be helpful because, nobody likes making decisions in a vacuum. And judges are not any different. So the appropriate context can benefit a judge and make a judge feel A, more confident in their decision, but B, will help them make what we would consider the appropriate decision. But there's a couple of other things too I wanted to go through with you.
Especially when an issue is complex or may be complicated for the court, we really can use this as an opportunity to provide the judge all of the education and the case law authority that'll be necessary for rulings that they're going to make. The jury is not present during pretrial, so this really is an opportunity to carefully brief all of these issues, to allow the court an opportunity to review the cases, to hear from opposing counsel, to consider their authority, and not only rule on the specific issues, but really gain in education about the case. The other thing I think that's so important is, as prosecutors, we want the court to know our level of dedication to litigation, to being appropriately prepared, and to really being available to the court in this setting to provide accurate case information and good authority. So part of it is we're also building the court's trust in our ability as prosecutors. And when we talk about intimate partner violence, and sometimes we're focused on an evidence-based case, this really is important because we want to ensure that the evidence that we're presenting is going to be admissible at trial. And so in that regard, what we're also doing is previewing the strength of our case for the defendant. The defendant is present in court, is hearing the judge's rulings as to the admissibility. Forfeiture by wrongdoing might be a great example of that, how the victim who is now absent due to the offender's intentional conduct, that a statement made earlier by the victim is going to be admissible. And so that really can translate to an offender the strength of the case if the offender is going to proceed to trial. One thing I think that's really important, we'll be asking the court for numerous rulings, and we need to ensure that we're having conversations with all of our witnesses who might be providing information in that area. The last thing that we want to have happen is for a witness to unintentionally violate an order because simply that information was not conveyed to them. So involving witnesses and letting them know about the rulings and answering their questions about the testimony they're going to be asked is also important to our pretrial work.
Mm-hmm. I want to just put a pin in this idea of the novel issues and reflect when I moved from doing a lot of domestic violence work to doing what at the time was new for our courthouse, human trafficking work. And much like everyone in the courthouse, including me, it was new. And when I was able to provide information well in advance of trial and do this motion practice, I'd often have judges that would go back, and later I learned that, they were talking to their fellow judges who were like, hey, have you seen this before? What do you think about this? And so it was like, it gave them that opportunity as well. And I think they appreciated it to sort of soundboard from their peers these issues that, to be fair and frank, no one had litigated before. There wasn't case law. We were depending on, some persuasive case law, some federal case law. And so I think that also gives the opportunity for a judge to feel like they have the time to educate themselves, and they'll be more confident and appreciate that as well. So when we talk about intimate partner violence cases, you've mentioned sort of the victim-centered and the offender-focused. What are some common motions that we might look towards, or areas of motions, when we're looking at that victim-centered piece in particular?
One of the examples that comes immediately to my mind is victim privacy. The defense may have provided a subpoena duces tecum, requiring the production of counseling documents. The prosecutor may not know that there was earlier a counseling relationship, but the offender knows he's in a relationship or was in a relationship with the victim. So defense counsel may have done that. Going back to, and we've emphasized how important it is to collaborate with the advocacy community and other victim service professionals, will be notified perhaps by that organization that they've received a subpoena duces tecum. So that kind of communication can really enhance our efforts as prosecutors to protect the victim. We may want to, for example, if there's information that we have in our possession about issues of privacy for the victim, we may ask the court to conduct an in-camera review to determine whether or not this should be provided, whether it's going to be admissible into evidence, and the court will then hear from the argument of both counsel to reach those decisions. In terms of other issues, rape shield is commonly an issue of concern for many victims. And in most states, I think, Jane, the defense is required to give notice of their intent to offer this kind of evidence, and there are certain time periods that are associated with it, but not always does that happen. So if we have a concern that this may be something that the defense wants to introduce, we can bring a motion in limine, and putting the defense in the position of advising the court what, if any, evidence they want to present, and then we can certainly argue it. Much better to approach it this way than hearing the defense delve into this kind of area on the witness stand, and then being in a position of objecting, asking that the jury be taken from the courtroom, and then advancing argument. So protecting the victim, that's something as prosecutors we always want to be focused on. Is there evidence coming in that's going to jeopardize safety or privacy? Is it going to be used for a purpose of harassing or embarrassing a victim? And pretrial really is our opportunity to let the judge know through motions what our concerns are and to address them with case law. We also protect the case, and we want the jury to be able to reach a fair and impartial judgment or verdict in the case based upon admissible evidence. We don't want them reaching these critical decisions based upon evidence that they should not have heard. And so pretrial really is our opportunity to ensure the integrity of this part of the process. It's so important. We also want to avoid a mistrial. If an issue is not previewed in pretrial, a risk is being taken with asking a specific question. That may even lead to a motion for a pretrial. So when in doubt, if there's any concern with relevance and materiality, or maybe complex issues that this particular department has not heard before, it really is, it's important to use the opportunity of pretrial. And again, the ends of justice really do require that, so that the jury is in a position of fairly deciding this case based upon admissible evidence.
Mm-hmm. So I put this slide in, and I don't know if it's silly or not, but sometimes I think, especially in intimate partner violence cases, where you may have a victim and a defendant who have known each other for some amount of time, these cases get kind of messy. I'm sure there's a better word for that. And I've definitely been in situations where the defense wants to bring in all of this stuff that happened, and it was 15 years ago, and all of a sudden the judge will like hold up the hands and just say, you know what, everything's coming in. I don't want to deal with parsing out all these different pieces. And I think it's easy for a prosecutor to be overwhelmed in situations like that and need to remember, okay, what are the basics of our evidentiary code? What are the foundations? And so I put in this slide, we admit things that are relevant to the charge, material to the charge, and have a proper purpose. And we exclude things that are irrelevant, immaterial, and have an improper purpose. And I think it's just important to sort of like make sure that everything we're looking at when it comes to, in particular, this character evidence that we so often see in intimate partner violence cases, to start with this foundation.
And this is the kind of analysis that as prosecutors, we want to really think about this early on. We should be prepared at a second's notice to explain to the court what the relevancy of this proffered evidence is, why it's material and probative, and the reason that it needs to come in. So that's the level of analysis that we need to bring to our evidence, and also the defense's evidence that we expect that they're going to offer in. We need to look very carefully at all of this, bring the motions early on with appropriate notice to the other side, and note it up for pretrial. The other thing is we learn a lot in this process through defense arguments, where they're headed, what their ultimate goal is. And so this analysis really can open up the door to that kind of, as this slide says, preempting improper strategies when used by the defense.
I got our slides a little out of order here, but I think you're absolutely right that even if, like you mentioned in Rape Shield, there's an actual notice requirement that defense has. I often found that defense attorneys would be making attempts to admit evidence like at trial in the middle of, this and things like that. So I found it really helpful to sort of guess almost or preempt what I thought, okay, this is what they're going to try to bring in. And so I was always trying to put my defense attorney cap on and think, okay, what do I think they're going to try to bring in at the last minute, where it's going to be very uncomfortable or impossible to keep this information from the jury, and then to preemptively put that in a motion in limine, saying defense shall not be, allowed to admit or should be prohibited from admitting X, Y, and Z. But you kind of have to do a little detective work to figure out, okay, what do I think they're gonna come up with? So what are some strategies to do that besides, like you mentioned, your own pretrial litigation can expose some of those strategies?
One example that really does come to mind, we may litigate Rape Shield information and may have a ruling from the court, and we've got to craft these rulings very, very carefully, prohibiting reference to this specific area during jury selection, during opening statement, through direct or cross-exam inquiry of any witness, in closing argument. It's got to be very carefully drafted and specifically list out what the court has ruled, what information cannot be elicited or what information cannot be argued. Because one of the things that may happen, there may still be an examination of a witness with a subtlety raised. And so we've got to be ready for that as well, and then be prepared to review that ruling, to ask the court to determine whether or not that may violate the other order. So it's this kind of analysis and readiness that really emphasizes how important pretrial is and really how pretrial can actually be a bridge to trial and how we can be even better prepared to respond to arguments made at trial.
Mm-hmm. And you can get a sense of this by listening to maybe arguments that are made during a bail motion, or if there are defense witnesses, making sure you're interviewing them, or if the defense is going to interview any of your witnesses, that you're present for those with the permission of the witness. And then you can kind of get a sense of what that might be. The victim may be able to tell you, and they know the defendant as well, and be able to say, I know this is probably what they might say at trial. So lots of ways to sort of get your defense attorney cap on, and then figure out, okay, now how can I strategically address this and preempt it? When we are looking to admit evidence, right, that is relevant, that is material, and there is a proper purpose of it, these are some of the arguments for admission that I've seen happen and that we've talked about in various elements of this series. Over the course of this series, we've talked a little bit about 404B evidence, or you may be in a jurisdiction that has some admissible propensity evidence in certain cases. But I also want to sometimes think about being ready to admit evidence when you want to rebut maybe something that comes up of a self-defense argument that may come up in the middle of trial.
And 404B is a really good example of that. We will have previewed this with the court. The court will have ruled. If the court rules that 404B is not admissible in our case in chief, we want to ensure that in our conversation with the court that we're laying the foundation that if, for example, this becomes probative and relevant and material during the trial, we would like to have an opportunity to address this with the court again. So that does two things. First of all, it lets the court know that we know that things develop at trial and things may change somewhat. And secondly, it is a communication with the defense that if they go into certain areas, there may be an effort on our part to raise 404B again. Sometimes we all know as trial attorneys, sometimes the defense may somehow open the door to evidence that has been determined inadmissible. And so the best practice when that occurs is not to offer the evidence. The court has already ruled that we cannot, but it's to seek the permission of the court to respond now that the defense has opened the door. But again, all of this preparatory work really comes into play at trial. It's so important. And when we look at relevant and probative evidence in our cases, we're looking beyond the elements of the crime. That's important. We need to prove them beyond a reasonable doubt. But the context of the relationship may also be critical res gestae evidence that really sheds light upon certain elements of the crime. So in that regard, it's also important for us to offer evidence that establishes salient aspects of the relationship. Propensity evidence, as a general rule, is not admissible character evidence, but there can be exceptions to that in a case. And that, again, should be litigated earlier. And looking also, as we mentioned, at the offender as well as information to strengthen our case, consciousness of guilt, leaving a jurisdiction immediately after the commission of a crime, involving leaving a job or leaving other circumstances, that may become important evidence of consciousness of guilt. We also want to look at evidence when we anticipate, for example, self-defense in one of our cases. We want to look at evidence that really will run to the issue of not a bona fide claim of self-defense. And so what we need to do, we need to back up before even making these arguments and really take a deep dive into all of our evidence. What do we need to prove? The elements of the crime, the context of the crime. What do we anticipate the defense is going to be? And that's how we begin making these critical decisions for motion practice at pretrial.
I wanted to include this Federal Rule of Evidence 403, which is where you can exclude things that are deemed relevant if their probative value is substantially outweighed by the danger of one or more of the following, being unfair prejudice, confusing of the issues, or misleading of the jury, undue delay, wasting of time, or needlessly presenting cumulative evidence. Because I find that in intimate partner violence cases, more than in other cases, this is something that the prosecutor also needs to be ready to argue when it comes to things like unfair prejudice, confusing the issues, misleading the jury, because that can be something that the defense may want to do, because as we try so difficult to keep the spotlight and the narrative on what did the defendant do, we know a common defense is to try to shift that spotlight and say, what did she do? What did the victim do? And we know that's a common strategy. And so we also need to be prepared to make these arguments as well.
Right. And that's a great point, Jane. Very frequently the defense will argue cumulative evidence, and we need to be ready to respond to that, because the evidence should not be cumulative. We might be talking about perspectives of different perspectives of varying witnesses talking about the same act, but even that variance in perspectives can be important to persuading the jury about the occurrence of an act. So we need to be ready to argue that it's not unduly prejudicial, it's not cumulative, but the jury, as the trier of fact, needs this information in order to do their work in carefully analyzing the evidence.
I also included this because Rape Shield, even in intimate partner violence cases, even if it's not a charged crime, because we know there is, there may be an intimate partner violence case that involves sexual assault, but it also just may be something that the defense wants to bring up for other improper purposes, and to look back and to remind ourselves to not just look at the statute, but really analyze, like, what is the purpose of this statute? And so the advisory notes here say the Rape Shield rule, which really is a codified rule of relevancy, aims to safeguard the alleged victim against the invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and the infusion of sexual innuendo into the fact-finding process. I think this type of sort of legislative intent language can be helpful for us to recognize, not only in this particular evidence code, but in others as well. Like, what is the foundation of why we have the rules that we have? And that can be really effective when we're making our arguments or writing our briefs about admissibility and exclusion, trying to bring it back down always to what is the underlying theory of either admission or exclusion, and making sure the court is making the decisions based on that. So wanted to kind of shift a little bit, because other than the sort of evidentiary pretrial motions we've been focused on, there are a lot of discovery motions that you'll be dealing with pretrial as well. And that can be in the form of a motion to compel, or like that you mentioned before, subpoenas ducis tecum, which may, it came when you were discussing it. I was wondering if we were going to have time to talk about this sort of pseudo subpoena that comes to us, but is looking for like counseling records. And sometimes we may need to be collaborating with an outside attorney to quash those motions or those subpoenas, because we may not be the actual party, but oftentimes the court will let us sort of stand in and articulate a position on behalf of that motion to quash. So motions to compel and motions for subpoena. So these are really what guide us when it comes to, okay, what are we turning over? We have our statutory discovery rules that are separate and apart from our due process obligations, typically enumerated as Brady and Giglio. And the reason I want to make that distinguishment is that it came up once where the prosecutor or the defense attorney did not invoke discovery. So the prosecutor's like, I don't have to turn over discovery because the defense didn't ask for it. And so, and then then we were thinking about it, do you still have to turn over Brady and Giglio? So the courts have been very clear that those are actually due process rights of the defendant. And so those obligations follow us despite whether a defense attorney asked for discovery or not. So those are some of the things we want to think about with discovery. Also, I think more and more we're getting requests for discovery that are almost sort of directly to the victim. And so we may be asked to we may be making arguments such as, this evidence is not within our care, custody, and control. Anything in the custody of law enforcement, we know that is within our purview, but that doesn't extend to items that are under the care, custody, and control of our victims, because they are not technically parties to the case and are not subject to criminal discovery, typically. And then, the Victims' Bill of Rights also in many jurisdictions will have additional just enumerated rights of the victim to remain free from harassment and to have a right to be safe throughout the criminal justice process. So these are kind of the things that guide our discovery. But we know things are going to come up anyway. So I was going to ask you, this comes up all the time, what do you need to turn over as a prosecutor when there are relevant text messages on the victim's cell phone?
One thing that we might want to do in this situation is step back for a moment and have the conversation first with the victim about the need that law enforcement has for information, determine whether or not that is stored on the victim's phone. Informing the victim and explaining this to the victim is really important. If there is either a consent or a search warrant that's going to be directed, we need to very carefully draw the parameters of the search only to a certain day or a certain event with certain information. In this way, we can protect the victim's privacy to the extent that's possible. So if this information is obtained by law enforcement and there still are some privacy concerns associated with it, the in-camera review or the chambers inspection of this particular record can be an approach to take, and making sure that the court is given the appropriate context and can make a decision after hearing argument whether or not it needs to be provided. If it is provided, the second thing that usually occurs is a defense request for additional information. We don't know what happened before, what happened after. We have reason to believe that something else happened after. And here's an area that we really need to give attention to, because in order to appropriately argue that they should have additional information from the victim's phone, it's not a fishing expedition. There needs to be a showing of a reasonable likelihood or expectation of certain information. And we need to make sure that the court is really focused on that in the argument. But I think it really does begin with the conversation with the victim and the need for that information and the restriction to certain information.
Mm-hmm. This is an emerging issue, and I think folks are starting to be a little bit more careful, because I have definitely seen cases where, oh, we need these text messages, and there could sometimes it's only a number of them, a small number of them, and they thought, well, we'll do a forensic examination of the phone. Well, that forensic examination is not limited. That is, you've got everything on my phone now. And I know that if I was a victim of a crime, that would be a very chilling outcome. If I wanted to say, okay, these 10 messages are relevant, but you want to look through my entire phone. So I think originally people were getting these forensic reports done because they thought this is the best way to do it, and the most secure evidence way to do it. And we've recognized now, we can actually capture that information in a more limited way through screenshots, screen recordings. And so I would say that communication, and then the follow-up being, what is the best way to capture this evidence based on where it is, how much it is, and what other information is there. And then thinking about redactions and your in-camera reviews. And again, going back to the very core, is this relevant, material, or exculpatory? And that's our obligation. And I do think, this comes up a lot because by virtue of it, if I have a forensic download of the victim's entire phone, let's say the police did that, the victim consented, and the defendant's only getting 2 pages of that. Of course, the first thing they're going to do is I want the other 1,000 pages of that. And in places where we have really striven to be, complying with Brady and turning everything over, there's this urge to just say, okay, you get everything. And I think these cases are a little bit different. I think we have to be a little bit more careful and say, you know what, let's make sure that we are complying with our discovery obligations, with our due process obligations. But we're also looking at the victim's privacy, and we're not just turning it over because that's the easiest thing for us to do, and we're never going to get in trouble for that. And we have, in-camera inspections are often a place where we feel like this is a safe intermediary where somebody else is making that determination. But I also think, I'm getting on a soapbox on this, but I don't think even the judge, doesn't have the right to look through a victim's entire phone. So just be really thoughtful about how you're communicating what you need from the victim with the victim, how you're preserving that evidence, how you're turning it over, and what you can do within your ethical obligations to keep the victim's privacy private. Oh, and here's all the things we just talked about: redactions, protective orders, and in-camera inspections. And we have a lot of information with Equitas I'm going to share at the end of this conversation that really expand upon some of those emerging issues that come with ethics and digital evidence. This is just the federal protective order statute reminding us that with good cause, we may be able to protect some additional information, or we may be able to protect the information from going any further than the necessary parties. So we often will do that, I know, with like photographs that are taken as part of a sexual assault kit. And if those photographs need to be turned over for a defense expert or something, a protective order would go along with that. Equitas can help you with that if that's something that's coming up in your cases. So these are some novel issues that I came up with because these are things that we get asked about a lot in our role as attorney advisors. Prosecutors and allied professionals often reach out to Patti and I and say, I've got this issue. We haven't had this before in my office. Maybe a victim that had asked for a U visa certification, a form of immigration relief that's available to victims of certain crimes, or digital evidence we've just talked about because I went on my soapbox, or forfeiture by wrongdoing that Patti talked a little bit about, where we've got a victim that's not available due to the defendant's intentional actions to preclude the victim from being in court. And now we're asking the judge to introduce that victim's previous statements. Or image exploitation, these new criminal statutes that are addressing, often referred to as non-consensual distribution of intimate images. These are all kind of new for all of us. And so what are the tools that we have, Patti, to make sure that the judge is educated through this?
Well, I think addressing these at pretrial is critical to our work. And one thing with image exploitation that's so important, if we have the image is part of our evidence, we can actually have non-dissemination orders entered by the court so that the defense may have an opportunity to view that evidence. That's only fair. Or sometimes to copy that evidence if an expert is involved, but not to disseminate it. And the evidence needs to be returned to the prosecutor at the conclusion of the case. So that's another way that we also have of maintaining victim privacy to the fullest extent that we can. And when we look at our work as prosecutors, part of it is casting light upon issues that the court may not be immediately familiar with. And one of the best ways that we have to do it, that also is important for our education as well, is to brief it, to prepare a memorandum. We've all written a lot of briefs and a lot of memorandums, and I know all of us can say that we learned something in that process. We really, in distinguishing those cases, could sometimes find a pathway to presenting evidence that's relevant and probative that maybe we weren't immediately familiar with. It also really informs our argument. We're able to refer to the cases and to argue very technical issues in a way that's easily understandable by the court and ultimately is going to be persuasive. Expert testimony is important, very important in our work prosecuting intimate partner sexual violence or intimate partner violence. It's so important because there may be victim responses to trauma or behavior that aren't immediately understood and may even be misinterpreted. And so having an expert to explain that these are common responses to trauma, or given the experience of the victim, this was certainly a foreseeable response to trauma, can really help the court and ultimately jurors to really understand the impact of the crime that the defendant committed and how this particular behavior or response was actually caused by the offender, and it was a manifestation of the victim's trauma.
Yeah, I think we have a lot of tools to educate. I would just also say not to forget to educate yourself, because the most effective argument you're ever going to be able to do is if you have, as the prosecutor, a full grasp of the facts, of the evidence, of the law, and of perhaps even the social science or the theories behind things like trauma. You've really got to educate yourself first to be an effective educator to the court. And that's a final plug for Equitas, because we're here to help you on all those things. I didn't even mean that to happen, but Equitas, it's our job to be on top of some emerging trends and to collect briefs from others around the country so that you don't have to reinvent the wheel. And we've done a lot of that work, and hopefully you'll take advantage of us as being resources, either just our website or attorney advisors such as myself and Patti. So going forward, thinking about pretrial motions, really being consistent with and previewing and a bridge to your eventual trial or litigation strategy. Thinking of the different ways to educate the judge, whether through motion, expert, argument, and educate yourself in the to begin with, and collaborate with those allied professionals that can help you better understand those pieces of your work that you may not be as familiar with, like immigration law or family law or things like that. Focus on protecting the victims and holding those offenders accountable, always remembering your ethical duties of being a prosecutor for your jurisdiction. Lots of additional resources. I mentioned some of these as we went along about digital evidence, about ethics, and common ethical considerations that come up when prosecuting intimate partner violence cases. We also work with a couple of partner organizations I wanted to highlight, including the National Immigrant Women's Advocacy Project. If you're working on cases involving immigrant victims or victims that have sought U visas, amazing resources there. The National Crime Victims Legal Institute, also wonderful as far as providing that legal support, really looking at it from the victim's point of view. And this is my information, our website. You can always get a hold of Patti through myself or our website. And a final plug for our office hours. Equitas hosts these the third Thursday of every month. And the sort of idea is to get, a practice of folks that are joining, talking about emerging issues, using each other as sounding boards, sharing resources and briefs, and hopefully enhancing all the work that you do, because it is, while an honor, we acknowledge the challenge of it as well. So we're here to support you. Thank you for being with us today. Patti, always a pleasure.
Thanks, Jane.
Take care, everyone.